Officer Day, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. We are on the record calling case number 1918030, Gravity Imaging versus City of Detroit. Our discovery is closed in this matter. Your respective appearances.
Howard Cohen appearing on behalf of the plaintiff, Gravity, P41346, Your Honor.
Morning, Your Honor. Sarah Doman, P79128 on behalf of the defendant, City of Detroit.
All right, our discovery's been closed for almost a month now. So I take it you guys are in settlement. Where are we on this?
Yeah, we're pretty close.
We're close to reaching a settlement. There are just a few terms that I need to go over with my client, but in terms of the numbers, I think that we have a tentative agreement.
All right, then what I'm going to do is I'm just going to give you another date. And in the meantime, if you get your paperwork and your other problems worked out, let me know and you won't have to appear.
Yep.
Does April 15 work for both of you?
Sure.
Yes, Your Honor.
Mr. Cohen?
Yes, Your Honor.
I'm going to note settlement close. That'll work?
Yes.
Yes.
All right, so what I'm going to do, we'll set you for April 15th at 10 o'clock. And hopefully you guys will be done the next time we get together.
Okay.
And if we finish it before then we'll submit an order, Judge.
Yeah, that way you won't have to come in.
Okay.
All right, everybody be safe. Thank you.
Thank you, Your Honor.
We're off the record.
Another one at 11. Should I just log back on at 11?
Yeah, because the other side can hear you.
Okay, thank you.
Yes, sir. Okay, let's see, Mr. Whitney McCombs. That's going to be 1789. Whitney McCombs is 1789. Weber and Olson's. That's Mary Jane Elliott. All right. Seem to be ready on case number 1918179. The file is entitled Jefferson Capital System versus Whitney McCombs. Your respective appearance.
Morning. Excuse me. Good morning, Your Honor. Brian Truba appearing on behalf of the plaintiff, Jefferson Capital Systems. My P number is 61752.
Ms. McCombs, unmute yourself.
Okay, hello,
What is your name?
Whitney McComb.
Ma'am, is it your intention to represent yourself in this matter?
Do I have another option
Yes, you can retain counsel.
from the court?
No, ma'am. The court only provides
Oh, well,
counsel
then
in indigent
I
cases.
guess I'm representing myself.
You represent yourself. So be it. You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind that lawyer bind you. Do you understand that?
Yes,
All right, where are we on this file, people?
Your Honor, since the last pretrial on February 16th, our office sent the defendant discovery. It's not due until March 17th. So we're waiting on our answers to see, to get a little more clarification on this case.
All right, so you need some more time. And what about you, Ms. McCombs? I'm sorry, Mr. Truba?
A little bit more time, Your Honor.
Ms. McCombs, are you intending to do any written discovery?
What is written discovery?
Discovery, ma'am, is your method of finding out the claims and defenses of the other side.
Okay. Yeah, I could use some more time.
Then ma'am, I'll give you some more time, but you need to get started on that. I'm going to give you then both. I'll continue your written discovery. I'll give you a return date of April 15th. April 15th. Does that work for both of you?
Does, Your Honor.
What about you, ma'am?
Yes.
Okay, we'll continue your written discovery. April 15th at 10 o'clock will be our next pretrial. I would urge you to get your discovery rolling, folks. Is there anything else we can accomplish today?
I'm all set, Your Honor. Thank you.
Anything for you, ma'am?
No, thank you.
Okay, then we're off the record. April 15th at 10 o'clock will be our next pretrial. Thank you for coming in.
Have a good morning, Judge.
You too, sir. Good morning, Mr. Kirschenheiter. What brings you here today?
Hi, Judge. I'm here on Cavalry versus Tanya Crawford.
Okay, I don't have your opponent yet.
Yeah, there's an attorney on it, Melissa Wilkes, but I have not seen her.
Okay, off to the waiting room with you.
Sounds good. Thanks, Judge.
Good morning, Your Honor.
Are you off with the other call, sir?
Yes, Your Honor. I apologize.
Oh, it's no problem. No big deal. You guys are both here on TrueScan versus City of Detroit. Is that right?
Yes, Your Honor.
All right, let's call the file. We are on the record with 20161-100, TrueScan LLC versus City of Detroit. This is the date and time set for motion for summary disposition that was filed on behalf of the defendant, City of Detroit. No respective appearances.
Good morning, Your Honor. Joe DeCruz, P84445 for the plaintiff.
Morning, Your Honor. Philip Hiltner, P77913 for defendant, City of Detroit.
This is your motion, Mr. Hiltner.
Yes, Your Honor. This is our motion for summary disposition. It is a straightforward statute of limitations motion for summary disposition pursuant to Michigan Court Rule 2.116C7. The no fault statute at MCL 500-3145 sub 1 states that the party suing for a claim for no fault benefits has 1 year to file their claim, file their lawsuit, unless there's been a previous payment on the file or notice of the accident, a notice of the claim. There was no notice of the claim or accident, no prior payment for a Mr. Williams, which is who they're exercising an assignment on his behalf. The accident was June 3rd, I believe, 2019. They didn't file until August 2020. So that would be after the 1 year statute of limitations.
He claims that the governor's executive orders provide him with additional time.
Well, as I understand this, both the statute and the orders, there has to be some sort of notice within 1 year. The city had no, outside of filing, there was no notice whatsoever. So they didn't file a claim with 1 year. They didn't file a lawsuit within 1 year. There was just no notice period within 1 year. as I understand the statute, is there has to be some sort of notice within 1 year, and I don't think the court's orders would affect that.
Let me hear it from Mr. DeCruz.
Good morning, Your Honor. 2 points that I'd like to point out. The first point is we don't have anything from the city disputing, other than this motion. We have nothing from the city that says they did not have a notice, that there wasn't a claim, that there wasn't an injury, that this person wasn't hurt. We have nothing from the city, no affidavit.
Let's stop right here, Mr. DeCruz. Is it not the obligation of the claimant to file the notice?
Yes, Your Honor, but we don't know. We stand in the shoes of the claimant. We stand in the shoes.
That's the point I'm making.
Correct. But
You have the evidence that you had a filing before the city was given notice before the filing of the complaint.
Correct, Your Honor, and we billed for services prior to that.
I'm not arguing the date of bill of services. Mr. Hilton's concern is that the city had no notice of this claim prior to the date of the commencement of the litigation. You said, as your response, we have no proof that that is not true, that is so. And my question is, it is the obligation of the claimant to provide notice. So I'm asking you, rather than asking Mr. Hilton, since it is not his burden to provide notice, if you have any evidence that notice was provided to the city prior to the commencement of the litigation.
Your Honor, I would tend to, I want to say yes, Your Honor, and I'm
okay. Why that was not included in your response?
Okay, Your Honor, I'm sorry, Your Honor. I keep it.
I read the response. I didn't see any demonstration from you that there had been notice to the city before the commencement of the litigation.
Your Honor, I would beg to say that the response is the actual bills that were sent to the city, because they billed for it. They billed for these services. The services were done from a provider for toxicology testing. They didn't just come out of nowhere. We didn't bill the city just out of nowhere. It had to come from somewhere. So they had a notice according to what I think a notice should be. Okay, now the court can obviously differ and whatnot, but we believe that is a sufficient notice. However,
are there any statutory requirements for what the notice has to be? Doesn't the statute talk about what has to be done?
I don't see, Your Honor, it doesn't say anything in the actual statute on what the notice is. It says an action for recovery of personal protection insurance benefits payable under this blah 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 can be commenced no later than 1 year, blah blah blah, unless the insurer has previously made a payment, unless written notice of an injury as provided in subsection 4. So Your Honor, and again, this is a toxicology, or I'm sorry, it's a scan. So I don't know, Your Honor. It seems like that's a notice of an injury to me. And again, the court may have a different opinion, but to me, that's a notice of something. And then my second argument, Your Honor, if you would allow me.
Sir.
Yes.
Please continue.
Okay. The second argument would be that, Your Honor, that the tolling provision by the state Supreme Court would have given us an extension on the statutory limit, because if a notice was given from the filing and the filing date was told due to the governor's executive orders and thus adopted by the Supreme Court, then in theory that should have told also the statute, because if that is the notice and the notice is the pleading, then the pleading would be told. In my opinion, Your Honor, I leave it to the court. That one is more of a stretch than the fact that we actually billed for these services, and defense is claiming that they didn't have a notice when it seems like there was a bill for an injury.
The bill that you say was for an injury, did you send that to the city?
Your Honor, the provider did, according to the records, send it to the city for payment.
When?
On it appears in August, Your Honor, August 10. The services were done on August 10. This was printed on August 14, 2019. So I'm assuming it would have been in August, but that is an assumption as I don't have it in front of me.
All right, let me hear from Mr. Hilton.
Yes, Your Honor, just I think a couple items in response. One is plaintiff's counsel said they haven't received anything from the city. We did send initial disclosures in November, which of course didn't include much because our initial disclosures essentially said we don't have a claim file for Rodney Williams because we had no notice of this claim. We also had an affidavit attached to our motion from a supervisor at the company that administers our claims, and she confirmed, right, there's no Rodney Williams claim. So our first notice of this was when we were served with the lawsuit in August 2020. And just one last item, if the court's at all inclined to deny my motion, I would ask that we open discovery. Discovery was never opened in this other than the parties are required to exchange initial disclosures. Because plaintiff has sued 3 separate insurers, it appears. So it certainly seems there, I mean, by plaintiff's own pleadings, it seems like there might be other insurers of priority. And so the city would want to do discovery on that if the statute of limitations defense is not granted.
All right. Court is prepared to rule on this matter. I think that this is a question of statutory interpretation. MCLA 531.45 contains both a statute of limitations relating to the commencement of an action and a limitation on recovery. The governor's executive order 202058 provided in pertinent part all applicable deadlines to the commencement of all civil and probate actions, including but not limited to the filing of any initial pleading, et cetera, are suspended. So insofar as Mr. Hilton's argument is that the statute of limitations protects him from 3145, I agree with Mr. DeCruz. The governor's executive order provides that period of limitations was in essence extended. So in regard to that, I agree with the defendant. However, as I indicated, 3145 provides both a limitation of action and a limitation on recovery. Continuing to read from 3145, claimant may not recover benefits for any portion of the loss incurred more than 1 year before the date on which the action was commenced. By its language, the order of the governor relates to the commencement of civil actions. It does not talk about a time limit on recovery. And I think that those two things, the case law has differentiated those two things within 3145. So my ruling is that although the lawsuit was filed timely because of the extension given by the governor, no recovery can be made for any services or bills incurred more than a year prior to the date of the commencement of the litigation. And my understanding is that all the bills you are seeking here, Mr. DeCruz, were incurred more than a year prior to the date the lawsuit was filed, that complaint having been filed August 28th of 2020. Is that correct?
Yes, Your Honor.
All right. Then for those reasons, the motion for summary disposition filed on behalf of defendant City of Detroit will be granted. You, of course, Mr. DeCruz, have an absolute right to appeal my decision. That appeal will be perfected within 21 days of today in the Wayne County Circuit Court. Basically, what I'm doing here is I'm differentiating between the limitation of action, the statute of limitations, which the governor's executive order spoke to, and the internal limitation not of commencement, but on recovery set forth inside of 3145. So I'll send out an order today. Thank you both for coming in. We are off the record.
Thank you, Your Honor. Have
Thank you,
a
Your Honor.
great
You too. Thank you both for coming in. We are on the record calling file number 20167-132, Calvary SPV versus Tanya Crawford. By notice dated February 10th, 2021, this matter is set for pretrial today, March 11th at 10 o'clock. It's currently 10:31. Your appearance.
Good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722.
Mr. Kirschenheiter, it's 10:31. The matter is set for hearing at 10 o'clock. The defendant has failed to appear. The default of the defendant is hereby entered. This is a some certain case, as I recall,
That's correct, Your Honor.
and you have submitted a proposed default judgment.
I could.
So I have one
submit-
here.
Oh, you have one?
Yeah,
Oh,
it came in the other day.
Oh, perfect.
It appears to be consistent with the relief sought in your complaint. The court will enter that default judgment.
Thank you, Your
Defendant,
Honor.
they haven't failed to appear. Have a good
Thank
day, sir. We are all.
You too. Stay safe.
You too. Oh. All right. All right. Let's see what we got. Okay. Mr. Cohen returns.
Yes.
Which file is yours, sir?
Gravity imaging versus Wayne County.
Okay. And Ms. Nonis?
Good morning, Your Honor. I've got Velocity versus Ballard, 758.
Plaintiff or defendant?
Plaintiff.
And Ms. Bears?
Good morning, Your Honor. I am Michigan Bell versus URG and DTE.
Okay. And you're plaintiff or defendant?
Defendant DTE.
One of two defendants.
Yep.
Okay. Well, I don't have a match for any of you. So you guys want to settle your cases between you? I mean, you want to do that? You can't do that then. Off to the waiting room with all of you.
I'm happy to take their money.
Waiting room for all of you. It's not going right. Ms. Greco,
Hi, Judge.
good morning. What brings you here
morning.
today?
I am here on behalf of the City of Detroit and Northland Radiology versus City of Detroit.
Okay, I don't have your other side as of yet. So off to the waiting room with you.
Okay.
Counsel, good morning.
Morning, Judge. How are you today?
I'm good. How about yourself?
Well, thanks.
What do you have?
This is the Michigan Bell v. URG matter.
Yeah, and who do you have?
I am with URG.
Okay, I've got two defendants, but I don't have a plaintiff yet on that file.
He will be here. We were just conferring.
Well, maybe this is he now. That Rob Zielinski?
Oh, Corey Meridew and Catherine Barris are the other counsel on the file.
Okay, well then you're off to my waiting room.
Okay.
All right, Mr. Zielinski,
Yes, good morning, Your Honor.
what file do you have, sir?
The file, it's case number 20152-723.
You represent Northland Radiology?
That's correct, Your Honor.
All right, then I think I have a pair. Let me find her. And let's get you in here. We can get started.
Okay.
All right, I seem to have a match set on case number 20152-723, Northland Radiology versus City of Detroit. Your respective appearances.
Robert Zielinski appearing on behalf of the plaintiff, P82851.
And Fiola Greco appearing on behalf of the City of Detroit, P83874.
All right, folks, our discovery is closed here. Where are we on resolution?
We're close, Your Honor. There's been a figure that's been communicated between the parties, and the only thing holding up a possible settlement is our client, plaintiff's client, is out of the office until Monday. So we haven't been able to confirm whether or not it's going to be accepted. So we're just asking for a little bit of time.
All right, I'm going to give you guys to April the 15th. Does that day work for everybody?
Yes.
How about you, Ms. Greco?
It works for me too.
April 15th at 11 o'clock. We'll continue your pretrial. And hopefully we can get this file resolved before that time.
I'm confident that we will, Your Honor.
If you're able to do that, you send in your closing documents and we can avoid the necessity of your Zoom appearance. All right, we're all set then. Thank you for coming in.
Thank you, Your Honor.
Thanks, Judge.
Ms. Olmstead?
That's pretty far down the road.
Morning, Your Honor.
The next issue that is a party's evaluation of the use of, how much the plaintiffs can they claim for damages here. Plaintiff's general damages model.
Your Honor, can you hear me?
Fair market
Barely.
value compensation.
Can you turn down the?
Carolyn?
I'm sorry.
Use of their imaging based
Um,
on generally.
Okay,
Back
can you hear me
someone
now?
else.
Oh, well,
I'm sorry?
their day rate is.
All right, what file are you here on?
This is Scan Clear or Scan Clear, Your Honor?
I think I have your phone.
You have my opponent?
I believe so. Let's get started.
And all that goes into evaluation, and really it's for us and the defendant to figure out if we can
All
try
right.
to resolve it in between what we're asking for and what they're claiming, or not. And that's really the case in a nutshell from plaintiff's perspective.
I've got feedback from somebody else. Let me make sure I have the right case.
Liability, insurance liability coverage involved here. I believe there are 2 carriers involved. One of us, other.
Let me try something here. Now, let me see if I can unmute you one at a time. That's not working. Apparently I'm doing it wrong. Now, I think I have everybody here now. Is this Scan Clear LLC versus City of Detroit? This is 201-67098, your respective appearances.
Good morning, Your Honor. Benedict Dramati on behalf of plaintiff P83337.
Good morning, Your Honor. Crystal Olmsted on behalf of the City of Detroit, P69202, excuse me.
All right. In this file, it looks as if we've just gotten our initial disclosures. That seems to be, we had not done that when we were together on February the 11th. Where are we on resolution now that the disclosures have been made?
Your Honor, I think we can get this one resolved if we can have a moment to go into a breakout room.
All right, let me see if I can do that. Some days I can, some days I can't. Let's see if it's going to work for me. Breakout room. That's going to be, I don't see your name there. Oh, there you go. I think I can do this. Okay, got Olmsted. Room 1. Okay, I think I've sent you both to the breakout room. Let me close the room and see if I got something else that I can do. Yep, they're gone. Okay. Mr. Harrison, unmute yourself.
Good morning, Your Honor.
Who do you represent?
Represent Wayne County, Your Honor.
Wayne County. I believe I have Mr. Cohen, so we can do your case.
Yeah, I believe this is in the gravity imaging matter.
Yes. Uh-huh. Okay, we are on the record. This is case number 20159-628, gravity imaging versus Wayne County. When we were last together, the administrator was just being dismissed. So now we're down to the 2 parties who really are arguing. Let me have your respective appearances.
Good morning, Your Honor.
Unmute yourself. Mr. Cohen, unmute yourself.
Yes.
Howard
Cohen appearing on behalf of Gravity Imaging, P41346.
All right, Mr. Harrison.
Good morning, Your Honor. Jason Harris on behalf of Wayne County, P62765.
Okay, now that we seem to have figured out who the proper parties are, how are we doing on our discovery? Are we about done?
Well, Your Honor, we recently served discovery about 2 or 3 weeks ago. I would expect we'll have answers soon. We are also in the process. We've partially answered discovery, not all. The other thing I wanted to inform the Honorable Court of is there's another case, Your Honor, regarding the underlying plaintiff in circuit court. I am actively, Your Honor, seeking authority from the Corporation Counsel, Mr. James Heath, to have a global arbitration for this case, Your Honor, combined with the circuit court case. And there's actually, Your Honor, two other cases, an intervening case in circuit court. So what we're trying to do, Your Honor, along with the underlying plaintiff, Mr. Andre Brown, and all the providers, including Mr. Cohen's client, we're trying to get everybody together. We would hope, Your Honor, in the next 45 to 60 days for a global arbitration to get rid of this case.
Okay, well, here's what I'm going to do. I'm going to give you guys an April 15th return date, and I'm closing your discovery as of that time. Then we'll see where, first of all, if there's going to be a global arbitration, and if so, whether or not it's going to be successful at getting your case resolved. So April 15th at 11 o'clock will be our next pretrial. Does that work for everybody?
Yes.
Yes, it does, Your Honor. Thank you. You said 8 a.m., Your Honor?
No, 11 o'clock, like today.
Oh, 11 a.m. I'm sorry.
You can come at 8 o'clock and wait if you want. I won't. So discovery closes. April 14th. And hopefully by the time we're together, our next time, you'll be able to tell me whether or not we're going to be able to do this global arbitration or not.
Sounds good, Your Honor.
In the meantime, if we're not going to be able to do that, all of your discovery will be done with me and we'll move on with my case.
Okay.
Okay? Thank you,
Okay.
gentlemen.
Thank you.
Thank you, Your Honor.
Good day.
We're off the record. Have a good day. Thank you for coming.
You too.
Okay, I don't, as of yet, have a pair. I have Ms. Nonis, who's here on the Velocity Investment versus Gregory Ballard matter. She's by herself. Ms. Barris and Mr. Degenhardt are here on the Michigan Bell versus Everybody in America file, and I only have defendants. What's going on, folks?
I'll reach out to plaintiff's counsel right now to see.
Yeah, because Mr. Degenhardt thought that he was following him into in the chat waiting room. He never appeared.
And we were just on the phone less than an hour ago. So, Kate, do you want to give him a call?
Yeah, he might have forgotten. I'll put you guys back in the waiting room.
Yep, I'll call him right now.
And as for me, Your Honor, this is just a follow-up pretrial. We do have a pending motion for summary that we needed to get a date from the court.
Okay, well, let's see what happens with the other side, see if they're gonna show up.
Okay. Oh.
All righty, we seem to have all right. We seem to have counsel back on file number 2016798, Scan Clear versus City Detroit, your appearances.
Benedict Dramati on behalf of plaintiff, P83337.
Morning, Your Honor. Crystal Olmsted again on behalf of the City of Detroit, P69202.
Did we settle?
Your Honor, we have resolved the matter.
Okay.
Of course, subject to City Council approval.
Up to the City Council approval. What is the agreed upon resolution here?
Your Honor, we have agreed, there's 4 MRIs that are in dispute. We've agreed to settle the amount for $2,500 per MRI, or a total of, is that $10,000?
$10,000. Is that your agreement, Mr. Giamatti?
Yes, Your Honor, that is correct.
And as I understand it, this is the agreement is between council, but it's subject to approval by the City Council, correct?
Correct, Your Honor.
Okay. Now, what I will do, I will, terms of your settlement have been placed on the record. I will dismiss the matter without prejudice. And when you get your City Council done and you get your other paperwork, send in your final paperwork with the dismissal with prejudice. Thank you both for coming in. We are off the record.
Your Honor.
Have a good day.
Thank you, Your Honor. Have a good weekend. Take care, Benedict.
Take care.
Thank you, Counsel.
Okay, so I got these 2 files. I'm still waiting. Nobody knew. We're gonna do Ms. Nunes. We are on the record calling file number 20159-758, Velocity Investments LLC versus Gregory Ballard. By a notice dated February 12, 2021, this matter set for pretrial today, March 11th at 11 o'clock. It's now 11:31. Could I have your appearance, please?
Good morning, Your Honor. Attorney Ashley Nonis, P77029 on behalf of plaintiff.
All right, the record should further reflect that this pretrial is set at our last pretrial date, February 12th, with the agreement of parties on both sides. That's the time and date. Despite having agreed to today's date, defendant has failed to appear. No good cause of that failure having been shown. The default of the defendant is hereby entered. Ms. Nonis, if you'd be kind enough to submit your default judgment under 7-day rule, I'd appreciate it.
Absolutely. Thank you, Your Honor.
Have a good day.
Thanks, you too.
Bye-bye. This is file number 20140-642. The file is entitled Michigan Bell Telephone versus Utility Resource Group and the DTE Gas Company. By notice dated February 12, 2021, at our last pretrial, a date and time was set for today's pretrial with the agreement of all parties. That date and time is today, March 11th at 11 o'clock. It's now 11:33. Your respective appearances.
Morning, Judge Ted Dagenhart on behalf of Utility Resource Group.
Bar number.
P80486.
Ms. Barris,
Good morning, Your Honor. Catherine Barris on behalf of DTE Gas Company, P81014.
so I have both defendants and no plaintiff.
Right, Judge. I know we were just on the phone with Mr. Meridew this morning. I know that we've been exchanging discovery, and I believe we are trying to settle this matter. I believe plaintiff indicated that we will start depositions in the next couple of weeks if we don't.
Let me stop right here. Where is Mr. Meridew?
I don't know. Kate, did you get in touch with him?
I called over, I talked to his assistant who said that the door was closed and that it was on his calendar, and he insinuated if Corey was not on in 10 minutes to call back, that she would knock on the door, but I had no way of knowing since we were in the meeting room.
Okay, well, here's the situation. We set this with the agreement of all parties. We gave written notice to all parties. And Mr. Meridew, for whatever reason, has elected not to appear. We have wasted everybody's time.
I can try one more time, Your Honor, to call if that's your preference.
No, that's not my preference. My preference is for lawyers to follow court orders. I didn't set this arbitrarily. This is the date and time that all of us agreed to. And for whatever reason, Mr. Meridew has failed to appear, and you've already reached out to his office. That's an exercise in frustration and futility. I will dismiss this matter without prejudice. I'll send out an order, and you guys have a great day.
Thank you, Your Honor.
Thank you for coming in. We're now off the record.